Okay, good morning. Welcome to the Creative Factor. My name is Brett Klisch. We've finally gotten to our last day. Today we're going to be having a session on trademark law and patents. Yeah, a session on patents. So, yeah. Sound. Can we get the podium mic on? Beautiful. And we'll do a Q&A afterwards.
So here we are at Toy Fair, all fun and games, right? Until you get a letter in the mail that says you're infringing someone else's trademark. All of a sudden it's not really playtime. You have to figure out, gee, is this something very serious? Well, it is, and it's one of the things I'm going to be talking about today. My name is Craig Morris. I'm the managing attorney for educational outreach at the U.S. Patent and Trademark Office, specializing in trademarks. So, let's cover trademarks right from the very beginning. Conceptually, starting with the basics. What is a trademark? A trademark is any word, it's any symbol, it's any design, it's really anything that serves to identify the source of goods coming from one company as distinguished from those coming from another company. Now, one of the first considerations, as I alluded to at the beginning, is making sure you're avoiding what is known as a likelihood of confusion. Confusion as to the source of your goods, your product. Why is that important? Well, again, as I mentioned, you may find that you receive a cease and desist letter. This is basically a fancy way of saying, stop it. Stop selling your product under your trademark because we believe that it infringes our trademark. Why is this so important? Well, most people, quite honestly, when they receive that cease and desist letter, first off, they ignore it. They say, why is this other company picking on me? Well, a few weeks later, the same letter usually shows up, and now it's on the letterhead of a law firm. Catches your attention a little bit more. So maybe you're able to reach out to that other company and find out, is there any way we can coexist in the marketplace? Well, sometimes you can come to an agreement, but usually, unfortunately, you can't, and instead you end up being in court. So the judge is going to have to make a ruling, and if the judge does find that you have adopted a trademark that is infringing someone else's mark, he could rule as follows. First, all product bearing that trademark must be destroyed. Second, all advertising material must also be destroyed. And third, if the judge determines that it appears that you adopted your trademark in an attempt to steer business from that company to your own company, you may have to pay punitive damages. Do you see why this is so important for a new company? You may find that suddenly you have no product, you have no advertising, and now you have no money. So it's very important to avoid the possibility of a likelihood of confusion. Well, what are we even looking at when we say a likelihood of confusion? We're looking at two very specific things. The first, are the two trademarks confusingly similar? They could be similar in sound, they could be similar in appearance, they could be similar in meaning. It's really anything that would give rise to the fact that someone would be confused as to those two marks. Now, it's not really enough to say overall that there's a likelihood of confusion. In the legal sense, we have to look at a second factor. Are the goods somehow related? Now here, quite honestly, that really is something we don't have to worry about all that much, because if you're in the toy field, your goods are going to be related. It doesn't really matter the specific nature of your toy versus someone else's toy. It's not enough to say, well, our toys are different. If they're both in the toy field, we're going to say those goods are related. So really going to focus on that first part. Are the marks confusingly similar, with the understanding that yes, the goods are going to be related, so it's even more likely that there's going to be a likelihood of confusion. So, trying to figure out, are the marks themselves confusingly similar? One of the first things you're going to want to do is perform a trademark search. How are you going to do that? Well, most likely you're going to start at the United States Patent and Trademark website. That address is www.uspto.gov. And you're looking for the Trademark Electronic Search System. TESS, T-E-S-S for short. That's where you're going to do your trademark search. Now, the important thing to remember is that you're trying to find marks that are confusingly similar. Again, they can be similar in many different ways. So you don't want to go into our database and simply type in your exact trademark and say, well, I performed my search, I didn't find any hits, I think this is clear. Because if you only search for your exact trademark, it's very possible that you're going to miss another mark that could be a problem for you. A mark that, for example, is phonetically equivalent. So the spellings are different, yet the marks are phonetically equivalent. We would say those marks are confusingly similar. So a good trademark search is one where you're thinking outside of the toy box. You're thinking, well, I don't know if that mark is in that database, but I want to perform a search that would potentially find that other mark. So you have to craft your search in many different ways. Now, our database includes all federally registered marks and applied for applications. What you're going to pull up is an overall record of that mark. You're going to see the mark, you're going to see the owner, you're going to see the goods or services. Again, remember that second piece of the test, it is very important, but in your particular industry, it's not quite as important because almost everything will be considered to be related. So really focusing on, are the marks confusingly similar? Now, to make this even more confusing is the fact that under U.S. federal law, there's no actual requirement that anyone seek federal registration. Through use alone, you can get what is known as common law rights, rights that flow from actual use, even though you've never applied at the USPTO to try to register the mark. Someone can have very strong common law rights because they used the mark before you did. Our federal database will not have any record of common law use. Again, our database only reflects applications and registrations. So in addition to searching our database, you should also do what is known as that common law search. You're basically using the internet to perform the search the same way you would search for anything else, using your preferred search engine, for example, Google. You're looking to try to find a story about someone using the trademark that you are interested in using. And if you find such a story, You have to then become a detective. You have to figure out when did that other party first use the trademark. Because if they used it before you did, they automatically will have superior common law rights. Common law rights can trump a federal registration. That's why it's very important to know, does anyone have these common law rights? Now, knowing that, you might think, well, if common law can be so strong, why even worry about a federal registration? Well, registration gives you things that the common law never can. First off, it gives you prima facie evidence that you are, in fact, the owner of the trademark. What is that evidence? Well, it is a federal registration certificate. If you find yourself in a dispute and you are back in court, you can present that certificate to the judge as a matter of evidence. Now, quite honestly, not all judges are well versed in trademark law. You're not trying to fool the judge in any way, but you're simply saying, as a matter of evidence, I'd like you, the judge, to consider this federal registration certificate. So the judge will look at that certificate. He or she will look where it says owner. It's going to have your name. That might be enough for the judge to say, well, obviously based on this certificate that says United States Patent and Trademark Office under the United States of America seal, that you are the rightful owner of this trademark. Now, at this point, you're not going to raise your hand and say, well, Judge, don't you want to consider their superior common law rights? You're going to be silent as to that, and because you have that certificate, that may be enough for the judge to rule in your favor. Having the registration also gets you into our USPTO database. So if someone knows enough to do a search, he or she will easily find you. If they find you, that may be enough for them to say, you know, someone already has the trademark that I wanted to use, I better select something else. That is a win-win, easy situation for you. You did not have to take that other party to court. They decided to use a different trademark because they found you in the USPTO database. Another thing that the registration gives you, again, that certificate, it can be presented to Customs and Border Patrol. Huge industry problem where counterfeit goods are coming into this country. Customs and Border Patrol has no basis for keeping out those counterfeit goods unless they can say, well, based on this federal registration certificate, we know that you are the rightful owner of this trademark. That gives us a basis for keeping those counterfeit toys from coming in to our country. So very important things that a federal registration can give you that the common law simply cannot. So again, first big concept when you're thinking about trademarks, making sure that you're avoiding a likelihood of confusion. Again, if you don't pay attention to that, it can have very serious implications. You can end up with no toys, no advertising, and potentially even no money if a judge would rule against you in any trademark dispute. The second big thing to worry about when you're thinking about trademarks and any new product line is that you're adopting a trademark that is a strong trademark. Now, when I say a strong trademark, that automatically means that there are others that are weak. How do you know the difference? Well, a strong trademark is going to be a mark that is either fanciful or arbitrary. Now, fanciful, it's not in terms of the product itself. You might be thinking, oh yes, I want my toy, for example, to be very creative. We're not talking about that. We're talking about the mark itself. A fanciful mark is something like Xerox, Kodak. Those words never existed in our language until someone said, you know, I want to put these letters together to create a word that's going to be a source identifier. Again, a trademark. That's the function of the trademark, to be a source identifier. Because those words were created specifically for that purpose, to be source identifiers, they are very strong trademarks. Now, equally as strong is what we would call an arbitrary mark. An arbitrary mark, contrasted with the fanciful, arbitrary is a real word, it's in the dictionary, but the relationship between the mark and the product is totally arbitrary. This, for example, would be Apple for computers. Apple, obviously a real word, but relative to computers, that relationship is totally arbitrary. That makes it a strong trademark. Now, not quite as strong, but still okay, is a suggestive mark. Suggestive would be something like copper tone for suntan lotion. That suggests that if you use that lotion, your skin will turn a beautiful copper tone. You have to think about that just a little bit. If you have to think about it just a little bit, it's probably okay. Contrasted with the next level down, descriptive. A descriptive mark is one that comes right out on its face. It describes a characteristic, a quality, a function of the goods. Descriptive marks are very difficult to register and very difficult to protect. With that said, unfortunately, many startups will adopt a descriptive mark, particularly if working with a marketing professional. Marketing professionals love descriptive marks because the marketing person is going to say, this is a great trademark for you because it will immediately tell your customer why they should buy this product. The mark itself is the enticement because they know something about that product right from the name given to that good. Now that might make sense from a marketing perspective, but always remember that trademarks are legal things. Ideally, marketing and legal would work hand in hand, but that's usually not the case. So don't be fooled if someone says this is a great trademark for you and you're thinking, well, gee, to me that only describes a characteristic of my product. Trust your gut feeling there. That simply is not going to be a good trademark for you because, again, difficult to register, difficult to protect. Now, there's actually one category that's even worse than descriptive, and that's generic. A generic mark is the actual name for that product. If you were coming out with a new dairy-based beverage, you really couldn't say, and my trademark is milk. Milk is simply the generic for that product. Now, quite honestly, most people do not make that mistake at the beginning. They don't adopt a generic word as the trademark. Again, through misuse over time, the mark slides into the generic category. Escalator, aspirin, zipper, dermis, at one point those were all registered trademarks. But through misuse over time, they became generic. The Otis Company had the registered mark Escalator. The industry generic was a movable staircase. It was the Escalator brand movable staircase. But over time, their own advertising people, they got a little sloppy. They took a shortcut. Rather than consistently saying the Escalator brand movable staircase, they started just calling it the Escalator. And soon everyone, regardless of what company actually made that movable staircase, everyone started referring to it as the Escalator. When that happened, it became generic, and a court ruled trademark significance has now been lost. So again, once you adopt a trademark, you want to be careful how you use it. A trademark is always an adjective. It's never a noun. It's been way too long since you learned about adjectives and nouns. Don't worry about that. A trademark is never a thing. That would be the noun. Okay? So Kleenex. People misuse this all the time. You sneeze and you say, oh, do you have a Kleenex? Well, because you don't want to take the time to say, do you have a Kleenex brand facial tissue? But that is the proper trademark usage. It is a Kleenex brand facial tissue. It's not a Kleenex. It's not a thing. It's not a noun. So you never want to take your trademark for your toy, for example, and start using it in that manner. That's the quickest way for you to slide into the generic category. Now, another consideration. So we've covered when adopting a trademark, avoiding a likelihood of confusion, making sure you're adopting a strong trademark. We hope it will be at the level of fanciful or arbitrary, maybe even suggestive, but you don't want to slide into descriptive, and you certainly don't want to be generic. Then a third consideration is, what is your business dream? What do I mean by that? Well, if you know that you're only going to be using your trademark in the United States, well, you don't have to really worry about this next factor, and that is, how might your mark play in a foreign marketplace? Is there potentially a problem if you want to sell your mark overseas? For example, Gerber Baby Food hoped to use their famous Gerber trademark for baby food in France until they found out that Gerber translated as vomiting. Kind of a hard sell for a food product. Kentucky Fried Chicken, they wanted to use their slogan, finger looking good, in China, except it ended up being, eat your fingers off. Again, a problem in another country. So if you think, gee, I hope to expand into other markets, you may look into, might my mark be a problem in that outside country? So it may or may not be a consideration for you. Now, once you go through all of this, and we're talking the preliminaries, mark selection, and it's really so critical at the outset to worry about mark selection. But once you've taken all the steps, you've done the trademark search, you know that there really is no confusingly similar mark, you know that your mark is a strong mark, you know that it would not be a problem in another country, then my office hopes that you will seek federal registration. Again, not a requirement, but again, it will give you rights that the common law simply cannot give you. Now, how would you seek federal registration? Well, we hope that you will file online using the online tool of the Trademark Electronic Application System, or TEAS for short. Electronic filing, it is not mandatory, but over 99% of our applications are submitted online. So certainly it makes sense if you're going to do it to do it electronically. It is cheaper, it's more efficient. Now, how important is registration in the toy marketplace? Well, it may help to point out that the highest number of registrations given out last year to Mattel. Obviously, Mattel, a huge player in the toy industry, but it helps to establish that registration is very important in your field. Again, overall, for all registrations issued by my office, the #1 recipient was Mattel. Now, if you go through the process and you successfully receive your registration, many people think, I'm finished. I have my registration, I did my work, I can now sit back. That's not the case. A registration really is a tool for you. It's not really protection. There's no such thing as the trademark police. They don't exist. Now yes, my office will take care, if we're doing our job, of making sure that we do not register a confusingly similar mark to another party. But what we do not do, again, is police the marketplace. Just because you have a registration, that does not mean that someone else will not try to use your mark. You never want to be the party that receives the cease and desist letter, but you do want to be the party that sends one out. If you are aware of someone else using a confusingly similar mark, you want to use your registration as the sword. It's not really a shield, but it is the sword. You want to use the registration as a basis for sending the cease and desist letter, because again, you want to stop that person from using the confusingly similar mark. If you don't do so, you may end up losing business. Why is that? Well, someone buys a toy thinking that they are buying it from you. They buy that because they're confused by that trademark, because it's confusingly similar. It turns out that that toy is really very, very cheaply made. That customer is very dissatisfied. In fact, the customer is so dissatisfied, they vow never to buy from that product line again. Quite honestly, you didn't do anything wrong. You have a very good, high-quality product. But the one thing you potentially did wrong was not trying to stop someone who's infringing using that mark, potentially with a very inferior product. So that's why it's very important to assert your trademark rights using that registration to serve as a basis for the cease and desist letter. Now, how long does the registration last? Well, unlike a patent or a copyright, a trademark can last forever as long as you take the steps to keep the registration alive. What do I mean by that? Between the 5th and 6th year after registration, you have to do another filing showing that you're still using the mark. Why is that? Well, unfortunately, most new businesses fail between the 2nd and 3rd year. We don't want our database to be full of marks that no one is using anymore, because we want someone else to be able to use that trademark. So between the 5th and 6th year, you do another filing saying, yes, we are still using this. Keeps you alive, keeps you on our register. Between the 9th and 10th year, you have to do another filing showing not only that you're still using it, but requesting renewal. Every 10 years thereafter, the same steps. As long as you do that, your registration can last indefinitely. Now, the good news is you don't have to remember this. Because as long as you keep a current email address of record with my office, the first day of that 5th-year period, the first day of that 9th-year period, we're going to send you an email reminder notice reminding you it's now time for you to do another filing so that you can keep the registration alive. So again, it's very important to keep that email address current. If you change it for any reason, you want to use our online form to update your correspondence address. We want to help you, but you have to help yourself. Now, that's been a very quick overview of trademarks. Hopefully you sense the importance of trademarks. I'm now going to turn the program over because there's actually another piece of this puzzle, if you will, and that's potentially the patent aspect. Mr. Richard Blank is going to speak briefly on the changes to the American Invents Act, which changed our system from being a first to invent to a first to file system. He's also going to talk about the role of a provisional patent. Now, what I'm going to do is make myself available back in this other little Lego area. Not even sure whether those are actual Legos. They look like Legos to me. Some would say, no, they're not. I don't know what they are, but whatever those, that gentleman can tell me what they are. Okay, there you go. But if I can infringe on his area, I will stay back there if you have a specific trademark question. Otherwise, Mr. Blank is going to cover some patent things for you. Thank you.
Thank you very much, Mr. Morris. I'm going to stress two main topics, and they're topics that come up over and over again in the toy industry, and they come up with inventors in the toy industry, and with a lot of the companies. And as Mr. Morris said, it's going to be the First to File Act, and what that means. Can everybody hear me? Okay, and the provisional patent. And some of the rules that people don't understand. Over and over again, I get from inventors and from companies questions or opinions as to what is okay and what is not okay in those fields. And they're usually, or many times they're wrong. They just don't get the rules, and it's important to have them. I just wanted to quote that Thomas Edison said, "To invent, you need a good invention and a pile of junk." And that's sometimes very true, because that junk can be so important and create, when you put it together, some new, great, imaginative toy and unique toy. I also wanted to tell you, I'll try this again. One inventor came into my office, it was actually many months ago at this point, and said that they invented something that could dry almost anything without using batteries, electricity, or plug AC electricity or DC electricity. So I asked that inventor, "What's the name of your invention?" And they said the towel. Anyway, so on September 16th, 2011, President Obama signed a very special new law into our set of federal laws. It was called America Invents Act. And this changed our whole patent system. Since I think it was 1952, we hadn't changed anything in the patent system or in the statutes or anything that went along with it. And this was a complete overhaul of the patent system. The main or most important thing was that he put into this overhaul that starting on effective September 13th, 2013, everybody who invents first but doesn't file, you're too late. Because if somebody else files, invents after you, but files first, they get superior rights. So, unlike trademarks where Mr. Morrison said that you get superior rights for being first, that's out the window in inventions. So some of the issues that come up with that is you have inventors and small companies with budgets, and some of them have gone through the patent experience before, excuse me, and know that it's kind of expensive. So we have our regular utility patents, they're called non-provisional utility patents, and they're expensive. There was something that was put into place before the American Inventors Act called the provisional patent. And the purpose of the provisional patent was to help you out a little bit with a little less expensive way to get into the process. And then from that, go on if it pays once you've had a little time with your invention. So provisional patents have become very, very important. The big issue is many patent attorneys don't really understand provisional patents, so they're explaining to their clients provisional patents, and they're not even getting it. The bottom line is that if you go to a surgeon or a doctor, you don't find them in the who's got the best price booklet, or who's got the best price on the web booklet. If you go to any specialist or any important type of, whether it's a lawyer or anybody else, most people, if they're going to do a special litigation, they'll try to find somebody who's a litigation attorney that's really good in that area. So what happens? All you guys, you inventors and you company owners, when it comes to provisional patents, you go and you Google the web and you find somebody who doesn't know what they're doing to really mess up your invention by doing something totally wrong with provisional patents before you even get to the non-provisional patent. The rule is the provisional patent has to be invention as the non-provisional patent. So when these guys on the web say to you, hey, can you write a paragraph about what you invented and pay me some money and I'm going to file it as a provisional patent, and you'll get that priority date of when I filed it and a patent pending, and then within a year you can file a non-provisional patent and have a more sophisticated lawyer write that up. That don't work. It does not work. Your provisional patent has to be basically what your patent, your utility patent, your non-provisional utility patent is going to be. And so many people miss that point. And then they only find out about it later. They find out about it when somebody wants to invest money in their company, or when somebody wants to buy their company, or buy the patent, or when all of a sudden they're in litigation and they say, well, we filed first. We have a patent pending from our provisional patent that happened last year or a year before our non-provisional. And the judge in the court says, no, you're wrong, buddy. You just wrote on your provisional patent, I invented a toy. And then in your non-provisional that a lawyer created a year later, it was a specific device and a specific toy for a specific reason, doing a specific function that was novel and unique and not done before. Well, that wasn't in your provisional patent. You lose. So, you know, I just dealt with a real nice attorney who's a patent attorney running the patent division of a major toy company. And she was very, very nice. She happened to be an examiner for 10 years, or more than 10 years, in the patent office. And then she went from there to work for a pretty substantial sized toy company. And we were reviewing my patents that she was looking at. That's what they do. They have experts look at them. And the experts look to see what it is. And they really look at it. have to be, the most important thing I'm trying to stress here is two things. It's first to file, so it's no longer, we'll wait and see, we'll see if we get any interest in our product, and then we'll file a patent. No, you file the patent first, and you file a real patent, not a ridiculous paragraph that doesn't describe the patent. So there's two things I have to make sure you walk out of here with, is your provisional patent has to be real. So let me just run through a couple other rules. And this is United States, I'm not covering international in this short seminar. I do have other seminars on international. You can fly around the country and figure out where I'm going to talk and go listen to the international stuff. I will tell you one point about international. This is another thing that so many people miss. You file a provisional patent. Everybody seems to know the rule, and they don't know the correct rule, but they know sort of a rule that says they then have a year to file a non-provisional. That's not exactly accurate, I'll go back to that. But what they don't know is they have that same year to file an international. They can't file a provisional, a year later file a non-provisional, and then they all think they get another year, another 2 years, and then they can file the international. That's not how it works. If you're going to do a PCT or some form of international patent, it's got to be done within a year of the first filing, and the first filing is usually the provisional. Or if it is the provisional, it's when that was filed. So here's another rule that people don't understand. People think that they get a year for the provisional patent, then they file a non-provisional. You get a year at most. If you're here at the toy show and you're presenting your product, and then 3 months later you file a provisional, you don't get a year. You get a year from when you disclose to the public the invention. So if you disclose to the public the invention in February of 2016, and you file in June of 2016 a provisional patent, you don't get a year. You get until the following February, 1 year from the first disclosure, not 1 year from filing the provisional. So let's see. Provisionals terminate. They don't turn into non-provisional patents. A lot of people think that they do that. A lot of people think that their invention is approved because they file a provisional. The provisionals are not examined. You don't know if it's approved or not approved until you file that non-provisional. A non-provisional is a utility patent that is filed separately. It's a separate application, a separate filing from the provisional. The provisional just terminates a year later, unless there is a way to convert a provisional, but it's really complicated and most people don't do it. But assuming you're going the regular, usual, standard way, your provisional terminates, and before it terminates, you file your non-provisional. If your provisional terminates on Monday, and you file your non-provisional on Tuesday, you're too late. You do not get the benefits of the provisional. It has to be standing and not terminated when you file your non-provisional. The other thing that most people I find don't know, just as a side note, is a provisional is a utility patent. There are two types of utility patents, a provisional and a non-provisional. And most people don't know that. So I just wanted to have a short lecture today, just a brief lecture on some of the important points. The first to file aspect, which is 35 U.S. Section 102, that's changed in the patent laws. Significant changes. It goes from first to invent to first to file. That causes a lot of problems in a lot of industries because your budgets come very much into play because now you've got to spend more money earlier to protect yourself. First to file is important. Don't forget about it. Don't file later. The rule still stands that you have a year to file from public disclosure. Don't wait that year. You file the day before your public disclosure, or the month before that, because it's first to file. Use the provisional as a tool. It's a great tool. But make sure you have a lawyer, a patent lawyer, draft your provisional and draft it properly, not a paragraph and a broad claim that makes no sense, which is what constantly comes to my office, and I have to tell them you got a piece of junk here. It's got to be done over its meetings. Make sure that a regular patent attorney does your provisional, and they do it basically like a non-provisional utility patent, covering all the aspects of an invention. I thank you very much. I hope that I covered something that you enjoyed or can take away from this lecture. I'm here for questions. You can ask me any question you want. Take my card and call me up. I'm out of all my current cards, so the cards that I have there you can take. They have my phone number, my email address, my name, my old address. Just cross out the address. Thank you very much.
Does anyone have any questions? Raise your hand. You, sir?
Thank you very much. That was very helpful. With respect to the provisional, if you have, as you say, you pass it through an attorney or you have the
Talk
attorney.
about it.
Oh, sorry. In the case of the provisional, once you have, you're working with an attorney, and you discover that there's an error or an omission with respect to that filing,
You cannot amend the provisional.
cannot amend
They
it,
do not
correct?
allow you to amend the provisional. You can amend a non-provisional utility. You cannot amend the provisional.
And then beyond that, I've spent between $500 and $3,500 having attorneys clean up or process my provisionals. In your experience, is that is there an expected standard of cost? In your experience, do you find that there's important range there? I don't see the
Price
difference between
range,
the
you
ones
mean?
I do.
You're talking about a price range
Yeah,
for a provisional?
yeah.
Well, there's also, besides provisionals and non-provisionals, so you have to budget everything, and there's international patents. I'd say $1 million to $2 million per provisional.
Okay.
Only
That's
kidding.
nice round numbers, that's easy. Also, yesterday it was discussed that when filing patents, that if you file, one of the presenters said that if you file the patent in Britain, that has the best coverage for the EU. Is there something comparable with trademarks in that sense? Do we know?
You're a little low, but I think you said that somebody told you if you file a patent in Britain, it is the best coverage.
For the EU, yes.
I don't think so. I think you should file the whole EU to cover the EU.
And that is a country by country.
A patent in Britain is not going to cover the full EU.
So it would be country by country in that case.
Well, I think your best bet is to file a PCT, Patent Cooperation Treaty filing, which covers 144 countries. I don't know, maybe they've added to it, maybe more than 144. But it was 144.
Very good, thanks very much.
Anybody else? Questions?
Anyone? Here we go.
Hey, Richard Jakey.
AJP.
Okay, so understood the importance of the provisional leading to the non-provisional and it not deviating much. I heard that the most important element is that at least one diagram be within the provisional that carries over to the non-provisional, and that's pretty
Yeah,
much the
false, false.
So
We've
they're
been
looking
through
at
this, JP.
so what I was told was as long as one diagram from your provisional carries into a non-provisional, and this is from a reputable toy
Must
patent
be an
attorney.
expert, I'm telling you it's false.
Okay, so what are they looking at? Everything between the two, because the application is completely different, if I heard you right.
If you have somebody that's going to pay you or your company money for your patent, based on you telling them that the patent was filed under provisional last year, February 9th last year, and that priority date covers into your non-provisional, which is this year, so you're a year ahead of everybody else. And they have their experts analyze it, somebody like me analyze it, and you show them one little diagram that doesn't cover the invention, it covers one little aspect of the invention, it's going to be thrown out very quickly. Not going to happen. The bottom line, the rule is, and there's court cases and articles over and over again, your provisional patent that you're maintaining a priority date from, to get that priority date and to utilize that provisional, it has to have the ingredients that the non-provisional has. They have to be carried forward from the provisional. It makes logical sense. If you have a diagram of the wheel of a car, and you're claiming a car, you can't say, well, because I have a diagram of the wheel of a car from last year, I've covered the whole car, and the whole car gets that priority date. When you think about it, it's very logical. You have to basically have the whole car in the provisional for it to count as the priority date for the non-provisional. Hope you understand that.
Okay, anyone else with questions? One more.
Thank you very much for the
with-
questions. I appreciate it.
With respect to classifications, we're in the toy world. Toy is a pretty wide classification, is it? This is all new to me. I haven't done toys before.
Classifications with regard to patents and
Yeah.
the field of invention.
Right.
Talk a little louder.
Oh, sorry. So in case you had, for example, a bow and arrow, and it was a toy and its athletic equipment, do you have to file that in two separate classifications as two separate patents?
Well, when they examine it, by the way, for those of you that don't know, because I get this all the time, they have a whole department of 7,000 people in the patent department in the patent office. They really examine utility patents. They really search every inch of the earth, and they really make it hard. You have to really work to get a patent through. So I got this one last week. I got called yesterday because I got a patent yesterday. Whenever that happens, we're always very happy because it's so difficult to get them through. You have to go through the whole process. And when an examiner calls, so yesterday I got a call from an examiner. They said, we're wanting to issue your patent. We want to make an examiner's amendment. Can we change these 5 words? A couple words, they wanted to change them, move them a little bit. That's a great, sounds great. When you get that call, it's fantastic. So the point I'm making is that they're going to examine it, they're going to put it into all the fields that they think you're covering. And they're going to have different code numbers for maybe 10 fields. If it's going to cover 10 fields or 10 areas that they're examining it for. Does that help you? But when you write down your field of invention, there's no rule or law as to you having to cover every field in that particular area of the patent disclosure. Anybody else?
Anyone else for questions?
Like Mr.
No?
Patent.
All right, thank you, Richard.
Okay, thank
It was
you.
fascinating. Thank you, everyone. Our next seminar is at 1 o'clock.